Again, welcome. I am John Miller, the founding attorney of Rock Solid Law and Title, a law firm that is celebrating 30 years. It seems amazing to me that that has happened. And our practice came up as a business practice. I was a litigator at the time and began to do much more work with small business owners and really enjoy representing the entrepreneurial small business owner. The entrepreneurial mindset is something that means a lot to me. That's funny. The alarm to tell me to get on this thing just went off again because I guess I paused it and didn't turn it off. And as part of everyone's business life, real property is going to occur in one way or another, commercial or residential. And so that is another area of special emphasis for my firm. And then the business owner typically needs to consider estate planning to take care of their family. So those are the three areas in which we primarily practice. Due to the requests, some specific requests from some clients about keeping assets private, which is one of the things we do on the estate planning side, and particularly real property. And in at least one instance, the homesteading of private property and keeping that private for various reasons, typically or which are specific to the client. I've really delved into, consulted with other lawyers around the state and done a fairly significant amount of research on this issue of how to keep ownership private. I'm sure each of you may have a different thought about why you might like to, or you might have a client who would like to do that. I think it is a very worthy goal in an era where people can find out most anything on the internet, where there are a lot of snoopers out there, where there are a lot of bad guys out there, right? A lot of fraudsters out there. So keeping privacy private is an emphasis for our estate planning clients. It's an emphasis for our real property clients. And indeed, it's even a lot of times an emphasis for our business clients. And I'll give you an example of how important that was for a business, which unfortunately I do not represent. Way too big for Rock Solid, but on how that worked out for them. For those of you that haven't been with us, we had been on a weekly cadence of Thursday morning webinars. I've recently decided to go to every other week for the webinars, and we will continue to do so. It occurs to me that I may do a series on this subject because there are three real components to it. And I could probably do a half an hour on each. So this morning, I'll only have time to kind of gloss over the top of the big idea. This video will be available at Rock Solid Law /videos at our website. So if you need to watch it again to kind of figure out what we talked about, it'll be there. Also, I have written an article. I'm not even sure I'm finished tweaking it. It may be final, but in any case, hang on to the end of the half hour, and I will let you know how you can get hold of that, which will have more detail than we're able to do today. So again, there are lots and lots of reasons why somebody might want to keep their ownership private. Celebrities, we have a lot of celebrities that love to move to Florida. A lot of people love to move to Florida, and as we're finding out every single day during the pandemic, right? Hello to the realtors online. I hope you're enjoying this market. I see a few on there. Anyway, celebrities like to keep it secret where they live, if possible. So we have come up with what I believe to be the best strategy in Florida for achieving this goal. It's neither simple nor straightforward, but it's attainable. It's not that difficult, and it's not that expensive. So carrying on, I'm not suggesting it's the only strategy. There are others. Everyone will be fact-driven to every different client. So I'm not chiseling this in rock and saying it's the only way to go. But at this moment in time, I believe, a 37-year lawyer who has experience in business, experience in real property, that this is the best way under the law of Florida at this moment. So I'm sure you can imagine, we all do, nefarious reasons why somebody might want to keep property ownership a secret, but there are a lot of legitimate reasons. And I'm sure each of you have some of those in mind that I would be happy to discuss offline at another time. A lot of people just like to keep their ownership of things private. A lot of people just like to keep the details of their lives private. Probably the best example of a long ago putting this concept into praxis occurred when the Walt Disney Company decided that Disneyland in Anaheim, California, outside LA, was not big enough, and they wanted to do something bigger. They did their analysis and realized that 75% of the population of the country at that time lived, hey, the sun's popped out, right? Lived east of the Mississippi River. So they wanted to put something somewhere. And of course, they thought of our beautiful state, Florida. They needed to acquire a huge amount of land, and they wanted to do it quietly. So they began in Central Florida, outside Orlando, to construct what we now know as Disney World. And through a series of transactions using kind of shadow companies, they acquired the property from 51 different landowners in unrelated entities so that no one could find out the intent of their project until they were ready to publicize it. Actually, it turned out that I believe it was the mayor of Orlando did it about a few days before Disney was ready to roll out their announcement. But by that time, they had acquired all the land they needed, and at a price that averaged $183 an acre. Can you imagine that? By Disney. Immediately after it went public, this is in the 60s, mind you, it went from $183 to over $80,000 an acre next to that. In doing my research, I read an interesting article. I knew there was one ranch owner that had never sold out to him. And the old guy finally died. And in 2019, the heirs finally sold a preponderance of his ranch, mostly wetlands that they'll use for mitigation, to Disney. So it took them from the 1960s to 2019, but they closed their deal. So I hope there was much champagne enjoyed on both sides that night. So listen, number one, we want to make sure that if we're dealing with homestead property, we in no way compromise the homestead protection under Florida law. The Supreme Court of Florida once called homestead protection the greatest beneficence ever bestowed upon a population by its government. If that interests you, there are videos on the website specifically about homestead. But you know how the Hippocratic Oath tells physicians first do no harm. Well, first thing we do is don't do anything to screw up homestead. And every strategy dealing with homestead in Florida must keep homestead intact. All right, so I see the sun's hitting me through the blinds. It's not bugging me, but if it's bothering any of you guys, just type it into the chat bar, and I'll get up, take a time out, and close the blinds if you need me to. But I'm on a roll, so I want to keep going. So listen, we're going to keep homestead. This is my big warning, okay? Please beware, buyer, beware. The strategy I'm about to describe is not recommended for do-it-yourselfers, right? You screw this up, it won't work, okay? And I've spent a lot of time in my business life fixing things that people would say, oh, I can get on SunBiz, I can do that, I know how to do this. And also some other people who are willing to create business entities for people, which I think should be the province of a lawyer, mess it up all the time. It always costs more to fix it than it would have been to pay to have it done right the first time. So, and I'm just talking about one of the three components right there. So this strategy is not for do-it-yourselfers. I've practiced law 35 years in Florida, and I'm just implementing this strategy now. And I interviewed a number of other attorneys around the state to confirm that this strategy is the best one. So I've heard of multiple tales of woe over the years from people who have lost thousands of dollars, as well as their liability protection, by inadvertently compromising their Florida homestead or messing up their LLC. So you can lose your liability protection. You can also lose that annual deduction. by trying to execute this strategy and not knowing what you're doing. So there's my warning. Be warned. Additionally, of course, this is a webinar. I'm trying to teach something. You cannot take this as legal advice. Anybody who wants to implement this, I will talk to you about that at the end of the session. How am I doing? I'm about halfway through. I got to speed up. All right. So the strategy involves the use of both a Florida land trust and a limited liability company in order to achieve the anonymity of ownership. It's essential that particular care be in the manner in which both documents are prepared and in the manner in which the deed is prepared. A misstep on any one of the three, and the cow's out of the barn, the horse is out of the barn, whatever your favorite euphemism is for, you can't unring that bell, right? Because once it's in the public records, who owns it, you can't undo it. So a Florida land trust is the first step, one of the first two steps, and it is created by creating two specific documents. One is the, sorry, I think I flipped the bad page there. Hang with me. Yes, I'm human. First, we're going to create a land trust agreement, which will provide exactly how the trustee administers the land trust under the terms of the land trust. Then we're going to create a proper deed, or do it in the best way, do it in the transaction where the property is acquired. Not saying we can't do it later, but better to do it this way, to convey the real property into the name of the chosen trustee in their fiduciary capacity. So the trustee owns the property specified in the land trust. The public records will only reflect the legal ownership of title to the real property as the name of the trustee, as trustee of the name of the trust. As an example, only the property might be held as John Miller as trustee for trust number 1234, or a business entity as trustee. So herein lies the first problem in keeping secrecy. If the name of the trustee is too closely identified with the true owner of the property, it'll be easy for meddling people to figure out who owns the land or home, and the strategy will be thwarted. So the beneficiary, which would likely be the grantor, you or your client, owns the Florida Land Trust and retains all ownership rights, including direction over the trust, and delegates the power of direction to another individual or entity. So if you don't have an arm's length person that's not too closely identified with you, it could be an entity, and we'll get to that in just a second. So the beneficiaries of the land trust, although they're not the legal owners of the trust, will not show up on any public record or database. Start to follow me about how cool this is? The beneficiary information of any kind cannot be disclosed unless authorized by that beneficiary, probably you, or ordered by a court. There's where it can fail. If there's a lawsuit and a court orders that, for instance, the attorney who might be the attorney for the corporation or entity turn over that information, then that person would be required to do so. One might imagine that in that instance, the court might have a good reason for doing so, like an illegal trying to hide assets or something like that. So because the beneficiary retains all ownership rights, the beneficiary of Florida Land Trust can still maintain his or her homestead status. Isn't that beautiful? Isn't that cool the way that works? I love this stuff. So the person wishing to establish the land trust is known as the grantor, and the grantor can also be the beneficiary. So you can set this thing up to benefit yourself. You execute the land trust agreement with the chosen trustee who you pick and name one or more beneficiaries who will become owners of the trust. That means you can also name your heirs, successor beneficiaries of the trust after you're no longer alive or able to be the beneficiary. Important point, beneficiary can exercise complete control over the real estate if that's what we provide in the land trust, and of course we would. It's how the trust is drafted. That's why, again, this is not a great do-it-yourself exercise. So it could be your home or any property that's held in that trust. An additional benefit of maintaining privacy is that land trusts are not filed with the state of Florida or made a part of any public record. So far, so good, right? Looks like I have a question. The question regards other states. I'm only barred in the state of Florida. So the advice I'm able to give or the discussion I'm able to have is about Florida law. In the event there were real property located in other states, I would, through my network, find a real estate lawyer in that other state, bring them in, and we could discuss an appropriate strategy under their state laws. So thank you. Great question. I thought I mentioned Florida, but we're talking about a Florida land trust. We're talking about Florida property. I am a Florida lawyer. I'm also barred with the Supreme Court of the United States, but that has nothing to do with today. I'm not a member of a bar of any other state other than the state of Florida. All right, so far so good, but the beneficiary owner of the land trust may still have privacy issues if the trustee is a person or entity too closely associated with them. So a strategy to resolve that issue is to utilize a Florida limited liability company, or LLC, to perform the role as trustee under the land trust. So the grantor will use the LLC as an entity separate from him or herself to act as the trustee. In setting up an LLC, the Department of State of Florida does not require that the owners or members be disclosed. I can say that there are other states which have even greater secrecy in their LLC laws, and those would include, I think both Dakotas, but South Dakota and Nevada as well, and I believe Alaska is a strong one in that regard. So Florida business attorneys, like my firm, regularly serve as registered agent for companies that we represent. If our firm is retained to organize the LLC, the firm can be listed as the authorized representative, and if requested by the client, as registered agent, which has the effect of maintaining the privacy that we're here to talk about. Other than the fact that the LLC has a relationship with a particular law firm, no other information will be available regarding the trustee of the land trust that we previously talked about creating in the public records. So you might be thinking, wow, this exercise is way too difficult. And it does require attention to detail, but the benefits of the strategy far outweigh the cost for the right client. We won't know if you or someone you represent is the right client until we talk about their particular facts. But in this process, the detail is handled by the law firm. And the process is fairly seamless for a client, just information gathering and some decision making. Essentially, you'll be building a wall against busybodies and gossips who wish to interject themselves into your personal business. You may wonder how much this kind of protection costs. Honestly, costs will vary depending on each individual situation, but the cost of this process is not cheap, but the value of the privacy afforded by this strategy and the asset protection far outweighs the cost. We're probably talking a few $1,000s, but I really can't quote that unless and until we sit and talk about your particular fact situation. The steps to achieving privacy of your ownership of your home or another Florida real property are reasonably straightforward, although attention to detail is required. All three documents must be drafted with care. This is the last time you want to use that form you got off the shelf or off the internet. I have a funny story about that. I was reading a contract one time for a business client. I'd already been a lawyer 25 years or so, and there's a term in there that I was entirely unfamiliar with. Now, I admit to not knowing everything, but after 25 years, I know most business law terms. What is that? So did what every good lawyer does and did the research. Found out it was a term of art in the law of Canada. This was not a contract having anything to do with Canada. This was a contract that somebody went out and grabbed on the internet. Because they didn't know any better, they used a Canadian form, which actually was, in many regards, inapplicable to the jurisdiction they'd chosen here in the States. So just a little cautionary tale there. All right. So when is the proper time to adopt this or another strategy? All right. So we can help clients who already own a particular piece of property. I'm in that process right now with a client. But the very best time to consider this strategy in order to maintain the best secrecy and the lowest cost is prior to the time the property is acquired. Okay, so as you are considering buying a piece of property, that would be the time that you would want to think this strategy through. And if you want to keep your ownership of that to be acquired property private, then that would be the time to implement this strategy. So we need a properly drafted Florida land trust in conjunction with a properly formed limited liability company that will be formed solely to act as the trustee of the land trust, and a properly drafted deed assuring that it conforms with the other two documents in keeping the true ownership, as you know, that's going to be the beneficiary under the trust, private, secret. So I believe this is the most secure method for keeping title to real property private. And here at Rock Solid Law and Title, I have named this strategy our anti-Buttinsky device. I thought that was pretty cute. Anti-Buttinsky, people that are trying to butt into your business are thwarted. So if keeping ownership of your real property private is important, we're happy to consult on the process. As I mentioned at the outset, I have written an article about this. I believe that it's fairly thorough. I just made a note in the middle of this presentation of an edit that I want to make to it. But I'll be happy to share that with you. If you would like to have a copy of that article, please send us an email at questions, that's plural, questions at rocksolidlaw.com, and just request a copy of the article, How to Keep Ownership of Florida Real Estate Private. If you get most of those words in there, we'll know what you're talking about. Additionally, if there are people on the call or you have clients or customers who might be interested in this, I will be happy to have a telephone consultation to discuss the process with them and see if that makes sense to actually schedule a consultation to implement the strategy. So, my friends, that is my very best dissertation on how to keep ownership of Florida real property private. I am very appreciative of all of you joining this morning. Before I let you listen to the Commodores again, if there are any questions, I think the chat bar is somewhere. Let's see if I can get my big finger in there. Somewhere in the middle of the screen. If somebody has another question, I'd be happy to answer it. Otherwise, I certainly appreciate you joining us this morning. I am John Miller, founding attorney, Rock Solid Law and Title. Hope to see all of you soon. Have an awesome day. We're still on. That's a great question. I just saw that one. How long does the process take up? The trust we can set up very, very quickly. But I would ask a week to two before purchase, preferably. And the reason is that, particularly in the pandemic, the Secretary of State's vendor, which is Sunbiz, has been slow in organizing all business entities, corporations, LLCs, and others, and in fact, in all of their actions. So it used to be that we could be fairly certain that we could have an entity set up in 2 to 3 days. Just can't reasonably make that promise anymore. So I would suggest to you that we would need, for certainty, a 2-week runway to get the process set up. And of course, that's from when we sit and consult and get all the facts together, and when you've made the decisions on who the various fiduciaries will be, your trustee, your registered agent, things like that. Hey, Sean, you're welcome. James, you're welcome. Oh, thanks, man. Okay, I look forward to hearing from you. I greatly appreciate that. Melody, good morning. Just saw you on here. I think I've greeted everybody else who hadn't jumped off the line yet. Have a great day. Raj, awfully good to see you, man. Or at least your name. Take care. Let me know if we can help. Bye-bye.